In a surprising turn of events, Masimo, a renowned medical monitoring technology company, has taken legal action against the United States Customs and Border Protection, CBP. The lawsuit stems from CBP's recent decision to permit the importation of Apple Watches equipped with blood oxygen monitoring capabilities during an ongoing patent dispute between Masimo and tech giant Apple. But here's where it gets controversial. Masimo alleges that CBP incorrectly concluded that Apple is entitled to import watches featuring pulse oximetry technology, effectively reversing its previous decision without giving Masimo proper notice. This unexpected move by CBP has left Masimo questioning the agency's commitment to enforcing intellectual property rights. Masimo, based in Irvine, California, has accused Apple of poaching its employees and misappropriating its pulse oximetry technology for use in Apple Watches. The company has also initiated separate lawsuits against Apple for alleged patent infringement and theft of trade secrets, which are currently being litigated in federal courts. In a significant development, Masimo successfully convinced the U.S. International Trade Commission (ITC) to prohibit the importation of Apple's Series 9 and Ultra 2 smartwatches in 2023, citing patent violations related to blood oxygen level readings. Despite this ruling, Apple continued to sell redesigned watches sans pulse oximetry that had been approved by CBP post-ITC decision. And this is the part most people miss. On August 14th, Apple announced plans to reintroduce blood oxygen reading capabilities to its smartwatches, stating that it had received clearance from CBP. However, Masimo argues that the agency's decision to greenlight the watches without consulting Masimo or providing a compelling rationale infringes upon the company's rights. Masimo asserts CBP's role is to enforce ITC exclusion orders, not to create loopholes that undermine their effectiveness. The company seeks an injunction from the Washington, D.C. federal court to halt CBP's ruling and maintain the ban on Apple selling watches with the blood oxygen feature. While spokespeople for Apple and CBP have yet to comment, a Masimo representative has declined to provide further details. This legal tussle between Masimo and Apple highlights the complexities of patent disputes in the tech industry and raises questions about the role of regulatory agencies in enforcing intellectual property laws. We encourage our readers to share their thoughts on this matter. Do you believe CBP's decision was justified, or should they have consulted Masimo before allowing Apple to import watches with pulse oximetry technology? Share your opinion in the comments section below.